Thank you very much for inviting me over. It's my great pleasure and an honor to be here presenting to you today on the anniversary event of the SE27. Of course, good day to everybody in the world, whatever time it may be. I'm just coming out of 5 intensive days of working group meetings where we've discussed numerous different standards for privacy and identity management, and I'm very happy to talk to you today about the specific topic of how these standards actually relate to one of the more contested regulations out there in the European Union, the General Data Protection Regulation. I'm probably not telling you a secret when I tell you that the GDPR in itself brings along a number of difficulties, and that actually has good reasons and bad reasons. The good reason for that is probably that data protection is one of the fields where regulation takes place and society is kind of trying to catch up with the enormous dynamics of technological development during the last 30 years for the purpose of the pun, with 30 years of SE27 being ongoing. It's probably been ongoing longer. We can look back with the first privacy sets of regulations in the 70s. But really the dynamics have kicked in ever since 2000, around 2000, maybe 1990. So data protection law to some extent is integrating the technological advances and domesticating it into societal needs. At least that's what it tries. Whether that is successful is a different question. And as you may have seen, if you've watched the discussions on the GDPR, there was a lot of influences from a lot of sides. We have never seen so much lobby influences on one single piece of legislation before. And that led to a legislation that is very hard to actually deal with because there's a lot of compromising clauses in the directive, in the regulation itself, which need to be laid out, and we're currently still in the process of doing that. But before we dive into how actually standards can help there with the concrete question of doing that in the context of the GDPR, and currently we're doing that, let me give you a couple of thoughts on how that relationship generally could be considered. So usually if we're talking about European legislation and standards, there's 2 approaches. One is, and that's seldomly used, that's really required or mandatory standards. In some cases, in regulatory frameworks in the European Union, we see them specifically asking and requiring to implement certain standards. And that is, I believe, all of the cases, these are CEN-ELEC standards, sometimes ETSI standards. But most of these cases will be in highly safety relevant areas where you really have to apply a standard if you want to have a product on the market in the European Union. The much more common approach, of course, is using a mechanism that's been developed some 10, 15 years ago, which is a harmonized standard. A harmonized standard, although it is mentioned in the regulatory framework, is not mandatory. But if you apply that standard, there's the idea that that is sufficient to demonstrate that you're compliant. So you may want to use a different approach, but then you're on your own to demonstrate that you're compliant with the regulatory requirements. But if you're applying that specific standards, there is the assumption that you're compliant. Well, now if we look at what is happening with the GDPR has taken a very different approach. We neither see harmonized standards nor mandatory standards in the GDPR. That may also come from the fact that it's called a general data protection regulation, and often the use for more harmonized approaches or for mandatory standards is much more sector-specific regulation. So really pointing to a specific piece or a specific standard in the GDPR would be beyond the point. But there's another reason why the GDPR didn't take that approach, and that is, again, back to the fact that we are using. We're in this highly dynamic field. So the European regulators opted to go for a different approach, which is effectively different forms of co-regulation. Namely, there's two mechanisms in the directive, in the regulation, which is codes of conduct and certification mechanisms. So these two mechanisms are in there, and in codes of conduct, you get together a number of entities that work in the same sector, and together you agree on a specific set of requirements and apply that, and then you can bring that forward to the European Data Protection Board if you're working on a European level, or to your national data protection agency, and get that kind of accredited. And by that way, you get also, when you apply that code, you get the assumption that you're complying in that regard. The other way to do it is via certification mechanism, which is very similar, but a little bit closer to what we see in current standard practices, where you have a certification body in between. So you have a set of requirements, then you have a certification body, you go to that certification body, you ask that certification body and propose that you're complying to these requirements, and it'll put a stamp on your product or what have you, and say, yes, you're certified, complying to that standard. And again, if that is a certificate under the GDPR, according to Article 42 and 43 in that matter, then there is the assumption that you're in compliance. And again, that specific mechanism has to be brought before the European Data Protection Board or your National Data Protection Authority before you can actually apply that. So very different from what we usually see, but for good reasons, I guess. Problem though, GDPR entered into force some 2 years ago. We currently have no European-wide code of conduct, nor any certification that has been accepted by the European Data Protection Board yet. So we might say we're still in early days. Now, when we're looking at what we're doing in SC27, and especially in Working Group 5, we're doing, again, something different. We acknowledge that in this sphere, we're working on a global level. So we're developing international standards, and thus we try to define a set of requirements that will help people to meet requirements in all legislations. So we're kind of trying to find the common denominator between all legislative frameworks in that space. That's sometimes a challenging task, as you can, as you will assume, because there have been and there are very many different approaches in that field. And take into account that we're not looking for the least common denominator here. That would be easy. That probably would end up with standards full of empty pages. No, but we're really looking at the product of requirements, or the sum of requirements from all different countries. Hopefully, they will not be contradicting themselves or each other, and in that way, if you apply our standards, it will be easier for you to be compliant globally. Now that's quite a challenge, but certainly as an interim result, we can assume that we don't have direct legal implications of our standards, but they might prove to be very helpful. So before we now look into what there is on offer in the work of Working Group 5 with that regard and in context of the GDPR, let me give you a very brief primer on how we actually do standards development in ISO. So generally, it is a multi-step process where you start with a new work item project, a study period formally, now maybe a new work item proposal. And then if that gets accepted, you will move on to what we call a working draft, where experts are concerned in discussing sets of requirement and decide and wordsmith on the text until they feel confident that this is a document that can be presented to the next level. This next level is then the committee draft, is a level where the document is really presented more to the member organizations of the International Standards Organization. So in Germany, that would be the Deutsche Institut für Normung. In UK, that would be British Standards Institute, BSI. And there's similar organizations all around the world. So then this is discussed on the level of national bodies, and again, comments are taken in and the draft is further improved until the document finally ends up to be a draft international standard, a final draft international standard, and eventually, after the last minor corrections have taken place, it will end up in publication. From that, you may derive that it is quite a lengthy process, and you're probably right with that. Usually it takes between 2 to 5 years from starting a project until it's eventually published. So it's not exactly a specifically fast mechanism. On the other hand, the quality of this process, you can see there is many levels of quality assurance, and that usually yields very good results. Then if we now continue to look into how that works, and Ted Humphreys in the beginning has already weighed in on that, you also have to consider that ISO, of course, doesn't only do standards for privacy and identity management, but also for coded character sets or for artificial intelligence, for that matter. And even those two examples are just examples from one committee that's called Joint Technical Committee on Information Technology, and it's a joint committee between ISO and IUC, to be more exact. But there's loads of other committees in ISO and IUC on several different other topics. For example, I have the pleasure to chair a committee within ISO that's solely working on privacy by design for consumer goods and services, and that's a separate one. In that way, SC27, who is organizing this conference together with our dear host, is a very specific or a very special beast, because it's being only a subcommittee. It is very, very big and produces a lot of standards. Next up, where are we at within SC27? In SC27, there's 5 groups. One is working on ISMS and does deliver some of the most acknowledged standards within ISO. There is one on cryptography with a lot of interesting talks going on. And there's, of course, Working Group 3, which works on security evaluation, and Working Group 4 on security controls and services. And finally, there is Working Group 5, which what we are talking about today, which is on identity management and privacy technologies. And if you look at what specific areas they're addressing, you can derive that the work in Working Group 5 is a little more horizontal than the other topics. It spans across the different mechanisms that you would usually see in standards we use to describe techniques, guidelines, and assessments, but we also span from products all the way to environments in our documents. Now, let me give you a couple of examples of interesting projects which relate to the GDPR. First, let me an overview of those different projects, and I assume it may be hard to see on screen, which is kind of the whole picture of different projects that we have in Working Group 5 that relate to privacy. Including, for example, one document that works on how do we actually make privacy-friendly standards. But we have architecture frameworks. We have some areas where we have very specific technology requirements. For example, the 29101, which is on mechanisms for making things partially linkable and partially anonymous. And of course, there is fundamental standards and more application-oriented standards. Now, I chose to pick a number of those to give you examples, and I also want to use the occasion to relate our suite of standards with what we have in the GDPR. Now, if you look through the different articles of the GDPR, there may not be all of them who actually have relationship to standards, where you could actually find a way to say, well, a standard may help you apply that specific rule. But there's actually quite a bit, and there's also quite a bit that's already covered. For example, if we look into the definitions, the sole definition of personal data and pseudonymization is a very contested term. And we have some work going on in that field with our standard on privacy enhancing data de-identification techniques, which show you how you actually manage to pseudonymize data in a sufficient way that's sufficient under the directive, but also may show you ways to treat data in such a way that in the end, you don't necessarily have to consider it personal data anymore. On the principles level, there's the 29100 privacy principles, and I'll dive into that in a second. There's also some stuff on consent and information, which I'll weigh in a little bit. There's not much on data portability and access rights yet, so that's an interesting field maybe for interested experts to dive in. There's early work on privacy engineering, which is a technical recommendation. On the question of the requirements for data processors as opposed to controllers, we have a standard out there which is used fairly broadly. There's not much stuff in breach notification, but some mention of that in one of our most successful standards, is 27701. We have a standard on privacy impact assessment, which might relate to Article 35. We don't have anything on codes of conduct, but it might be interesting to see standards used as a basis for codes of conduct in the future. Finally, again, ISO is not a certification body, but standards can deliver a basis for certification. And the extension to the ISMS for privacy management, effectively a privacy information management system, certainly and already can be certified against in all contexts where ISMS certification is possible. But still early days on that area as well. We're working on more specific guidelines on requirements for the auditors themselves. But accreditation can take place in that area. So I'll give you 4 examples and dive into 4 of our standards in a bit more deeply. First of all is our privacy principles standard, and that very much relates to the privacy principles or the principles that we see in Article 5. But it's kind of the same principles in a different, formulated in a different way, come up by agreement between organizations all around the world. And that is a very important stepstone, was a very important stepstone in starting to dive into standardization in that field overall. As I mentioned earlier, there's very many different understandings of privacy and its implications. There's also very many different approaches in regulating that field. So before diving into concrete standards there, it was absolutely fundamental to agree what we are trying to achieve. And this is one of the examples of a standard that also, I believe, took nearly 5 years to develop and get published because it was such a long and intensive discussion that was needed. In the end, we came up with a very simple set of principles. They met very much with all the principles that you'll see in different privacy guidelines around the world. So the actually achievement may not be that much, but it lies very much in the fact that there is an agreement within the working group on the basis of our work. And we're lucky to see that this also very much matches with what we see in the GDPR. So we still seem to be in consensus about what we're achieving. And based on these principles, we can still support the GDPR. Next up is is the already mentioned 27701, which is probably our most successful standard. And it's really a broad set of requirements that an organization who already has an ISMS in place or wants to develop one, that it can attach to that ISMS process and also ensure that we're compliant with a lot of requirements in the privacy field. Data protection agencies in the past have already accepted ISMS certifications as a basis for their assessment of privacy compliance, or data protection compliance, I should say. And even more so, I think it will serve for such a purpose in the future as we're covering more and more of the requirements exposed by the GDPR. Bear in mind, though, that the set of requirements, the set of legal requirements will always be broader than the set of concrete technical requirements. So by applying 27701, you will be able to demonstrate a certain set of requirements of the GDPR, and an important set because it's the set that's very related to standard technological mechanisms. So you'll be fine on that side, but there may be additional legal compliance requirements that come into play for your specific processing. Now, next up is our privacy impact assessment, and that's one I'm a bit proud of, because we were on the market with a standard for privacy impact assessments even before the GDPR had a regulation for data protection impact assessment out there. And by that, we deliver a standard where we can see that we can apply for a lot of the requirements when you actually have to assess a data protection impact assessment, which you have to do whenever you encounter that your processing is in a high-risk area. So whenever you're processing data, you have to at least look at it to that level of depth that you know, okay, are we in risky areas here or not so much? And if you're in risky areas, you may want to use the 29134 methodology to make a privacy impact assessment and to mitigate these risks. There's others out there, there's other ways to do that, but certainly 29134 is one of the ones that is usually referenced in this context. And finally, one of the standards that are probably one of the most practical standards also for users is the 29184, which provides guidelines for online privacy notices and consent. And this standard is a mechanism, or provides for the time being, a kind of vocabulary. So you all know these privacy policies on websites, and nobody ever reads them. And one reason why people don't read them is because they can't be sure that the information they're actually interested in, it actually is in there. And the other reason is because they won't be able to find that information. Now, 29184 doesn't solve that problem, but it's a one step into the right direction because it delivers the first set of vocabulary and requirements in that regard. And we're continuously working on that. Ongoing work is on privacy notice and receipts, where we are providing a standard where you can actually provide your user as a controller with a receipt of what they actually have consented to, what process they want to have and what not. So keep an eye open on those documents, especially I think in the field of notice and consent. I think there's quite something happening that will also support the goal of having more transparency when it comes to data collection and processing. Now, that's for the overview, and I could stop here, but you may want to say, wait a minute, didn't we just all talk about privacy standards now? What about the GDPR saying talking about a general data protection regulation. And I want to spend my last couple of minutes on how the relationship is between data protection and privacy. And there are some fundamental differences, but it may not cause too much problems for our standards processes if you look into it in depth. So first of all, if you look into what data protection actually is, then you'll end up from a legal perspective in Article 8 of the Charter of Fundamental Rights of the European Union. And there it states that everyone has the right to the protection of their personal data. And this is what we usually mean by talking about data protection. And by that, it is very different from privacy. The term privacy is not mentioned in there. It's not in that clause. It has nothing to do with privacy, or only very limited with privacy directly. If we really analyze what is going on here, the concept of data protection is a very interesting concept, as it is a mechanism that intends to protect all fundamental rights. And it wants to protect all fundamental rights against the risks that stem from the use of ICT. If I want to keep it really short, that's the idea. So, and when we usually talk about privacy, we think about our private home and things like that. But it's really much more than that. If you look at the Charter of Fundamental Rights, there is liberty and security. Privacy is in there. There's family in there, thought, freedom of expression. There's the freedom of assembly, art and science, education, work, property, and the right to asylum. So data protection wants to protect against risks for all these liberties, and not only for the right to privacy. As such, it's a very modern concept. And it really acknowledges the difficulties that we're having with this highly dynamic, innovative field of ICT for the last couple of years. Now, you may want to say that we're running into troubles for global standards, right? Because there is a common understanding that we're only protecting privacy with international standards. Well, no. If you now look in depth what is going on in different jurisdictions and is discussed with the term of privacy, you will see that it also extends far, far beyond just protecting your home and household. It is usually a much broader concept that is discussed under the term of privacy, and I really want to clean up that misconception that when we're talking about privacy, we're talking usually about much more than the old concept of privacy. A professor in the US in 2006 made a nice analysis of what is already covered under what different cases we have in the US case law that kind of relate to that, what we are discussing as privacy. And you see all these different forms that very much match with what we're discussing in Europe as well. So while we're using different terms, in the end, we may just be talking about the same thing. However, there is one final notion that I want to point you on. Actually, there's two. One is a little joke. So if data protection protects all these, including personal data, we might run into an infinite loop. But the more interesting question is really, is that approach sufficient? Are we on the right track of really protecting against the risks that come with modern ICT by just looking at personal data? And that's what I'll leave as an open question eventually for the discussion or for you to take home. And thank you very much.